My name is Ann Ojeda. I'm a single mother and nurse anesthetist from St. Louis County, Missouri. I'm also the person behind LitigantOnTheLoose.com and the whistleblowing campaign connected to it. I've been the sole custodian and sole financial provider for my two sons for nearly a decade. They're 15 and 18 now. There is no incentive for me to do this unless I had no other choice. And it's not a comfortable thing for me to need to do. But I'm here today because the reality my sons and I live with is this. If a group of judges and attorneys can intentionally create fraudulent court records to commit a crime, how could anyone feel safe? The mechanism behind this crime is not complicated. In fact, I think the simplicity might surprise people. When we think about weapons used to commit crimes, certain images come to mind. But crimes involving public corruption are committed with something very different. They're committed with paper. The difference is that the individuals committing these crimes have the access and control required to weaponize official records. And when crimes are committed with paper, the people responsible can hide in plain sight. But when fraud like this eventually catches up to the people committing it, the evidence isn't hard to identify. It just requires comparison. Comparing documents like transcripts of hearings to the judgments that describe what supposedly happened. For example, an administrative judge refuses to hold a hearing on the day it's scheduled, but later that same judge enters a written judgment claiming the hearing took place. Not only did she claim a hearing occurred when it did not, the motion referenced in the fabricated judgment doesn't even match the motion that was actually scheduled for that day. In the evidence I've published on my website, the judges involved were so careless that they left obvious clues. In another example, during a hearing, a judge states on the record that he will add a paragraph to a consent agreement after it's already been signed by the parties. He did this so the document filed in the record would make it appear that the parties consented to terms they clearly did not. To see the fraud, you simply compare the document to the transcript of the hearing. But no one would normally suspect they need to verify whether a judge fabricated what appears in a case record. The reason the individuals responsible have avoided accountability is not because the evidence is difficult to identify. It's because they're using their power and influence within the same system that's supposed to hold them accountable as a shield. This kind of fraud does not require a law degree to recognize, but the people committing it are relying on something very powerful: the public's trust in the judicial system and the legal facade created by the detailed court records they fabricated. Before getting into more of the evidence, let's talk about where this all started. This crime ultimately stems from my divorce from my second husband, St. Louis County Attorney Rick Voitis. The full timeline of that case is available on my website. Under the evidence section, there is a link titled Case 1 Chronology. At the beginning of that case, the parties were permitted to file under our initials only. My former attorney, Susan Jacobson, informed the court that I had a domestic abuser who continued violating court orders intended to prevent his harassment of me. Because of that history, the parties requested that the case be filed under our initials for privacy. That domestic abuser was my first husband, Victor Ojeda, the father of my two sons. I divorced him in 2016. Mr. Ojeda lost legal and physical custody of our sons shortly after our divorce. He was later found guilty of domestic violence based on ongoing post-separation abuse and violations of court orders intended to prevent his harassment of me. You can review the full history of that case in the court records published on my website using the link titled Case 2 Chronology. Those circumstances were discussed with Judge Joseph Green when my divorce from my second husband began in the summer of 2021. That background is important because it meant Judge Green understood exactly what vulnerabilities existed in my sons' lives and mine, vulnerabilities that later became central to the crime that unfolded during my divorce from attorney Rick Voitis. During a hearing in October 2021, Judge Green raised the file in my divorce from Mr. Voitis to what is known as a Level 5 security designation within the Missouri court system. Cases filed under Level 5 security in Missouri's court system are known to be uniquely problematic because of the issues they pose to people's access to their own files. In fact, one Missouri news publication did a story about cases filed under that exact security level just this past January. These cases not only vanish from Missouri's public court database, but this security level can also severely limit a person's ability to monitor their own case file while the case is active. When a case is filed under Level 5 security, you're not notified when documents are filed. You're not notified when hearings are scheduled. You can't call the courthouse to ask what's happened in the case or if something new's been entered in the record. Without access to the active record, the filings, hearings, and orders, it becomes impossible to fully participate in the legal process in real time. Even when a case qualifies for increased security, a litigant can't be denied sufficient access to their own case file so they can participate in proceedings. Security designations don't supersede due process rights. Yet that's exactly what happened. I was denied sufficient access to my own active case file. Multiple attorneys were aware of the issue. Administrative judges were aware of the issue. The court's domestic relations department was made aware of it. And I formally reported it to the U.S. Attorney's Office for the Eastern District of Missouri. I met with an assistant U.S. attorney from that office. I explained that I didn't have access to the active case file or docket, and the issue was persisting, even though I notified court administration and met with attorneys who confirmed the issue existed. And that when I went to the records department at the courthouse, it took multiple trips to even get a copy of a transcript of what the file looked like at any given point in time. I got a certified transcript of the file in the fall of 2022 and showed them that what was in the file at that time did not reflect what had happened in the case, and that it could be confirmed by reviewing hearing transcripts, and that Judge Green was doing things like denying his division was in receipt of certain filings during hearings. But then in the transcript of the file, it showed they were received. But no one would know that those pleadings were treated as if they didn't exist at the time they were relevant. They'd have to review audio and transcripts of hearings, which no one does. Judge Green was recording that settlement conferences took place that did not, and he even filed a copy of a consent judgment that was unsigned by the parties that he knew I did not agree to. But then at a later date, he pretended I did, so he could claim that my contempt of that non existent consent judgment was the basis for my sons and I to be evicted from our home and a sale to proceed without my signatures on documents. Countless people knew Judge Green was committing fraud on the court, but it was clear that this culture of corruption's nothing new. No one was going to confront a crime that involved so many powerful people within St. Louis County's judiciary. Instead, there was an effort by St. Louis County administrative judges to conceal the fact that I had even reported this issue. When I raised the issue on record during hearings with Judge Green, he didn't correct it. Instead, he responded with threats, at times even suggesting I could be detained by court security when I was trying to raise the issue. But by formally reporting what was happening to officials responsible for overseeing the court system, I made sure there could be no question later that this obstruction was intentional. And that's where the mechanism I described earlier becomes important. If someone intends to fabricate a court record, even to the point of claiming that a consent judgment exists when no such document exists, controlling access to the case file becomes essential. Because if the parties involved could freely access the record as it was being created, the fraud would be much easier to detect and report. By April 2022, I began formally reporting the obstruction of my access to the case file and evidence that Judge Green was manipulating the record. I filed motions in the divisions of two St. Louis County administrative judges. Within just a few months of those complaints being filed, the situation took an unexpected turn. Instead of holding a hearing regarding the allegations that Judge Green was committing fraud in the sealed divorce case of a local attorney, The administrative judge of St. Louis County Family Court did something very different. He assigned Judge Green to preside over a second lawsuit involving me. That lawsuit was filed by my first husband, Victor Ojeda. Mr. Ojeda lost custody of our sons in 2018 and had a history of violating the court orders protecting us from his ongoing harassment. Those violations were known to Judge Green. The timing was not coincidental. Judge Green now had authority over the case record governing the orders protecting my sons and I from Mr. Ojeda's harassment. And at the same time, I was exposing his criminal misconduct in another case he was presiding over. Judge Dotson knew that the respondent named in that lawsuit, me, was the same person requesting a hearing about judicial fraud in a sealed divorce case. The result was that Judge Green was placed in control of two case records involving me, one sealed and one public, shortly after I began reporting evidence he was committing fraud. Once Judge Green began issuing orders in both cases he had been assigned to, the situation escalated quickly. What followed was a flood of filings and orders, each building on the premise of the last, until a detailed court record had been constructed that contradicted factual reality. Because these claims appeared in court orders signed by a judge, they carried enormous authority. Most people assume those records must be true. But when those records are compared to the underlying evidence, the contradictions become clear. The escalation began first in my divorce from attorney Rick Voitis. When I refused to consent to the terms they wanted me to agree to, they simply pretended I had signed a consent judgment that I had not. That document does not exist. Yet Judge Green claimed it did in order to assert jurisdiction to evict my sons and I from a home I owned with Mr. Voitis. On July 26, 2023, Judge Green entered an order evicting us from that home. That order relied on the claim that I had requested the court execute a sale of the home before marital assets and liabilities had even been identified or divided. But that document does not exist, and that is why it's never been produced. When I pointed out that discrepancy, the response was not correction. Instead, the audio record from a May 2023 hearing captures Judge Green threatening that my sons could end up without a parent if he placed me in jail. This became a pattern. When I stated facts on the record that contradicted the narrative Judge Green was constructing, the response was escalation, threats, coercion, and attempts to silence me. At the same time, me and my son's lives were being destabilized by what was happening in the sealed divorce with Mr. Voitis. The second court record, involving my domestic abuser, Victor Ojeda, became a means of retaliation. Judge Green attempted to make it appear that while he was displacing my sons and I from our home based on fabricated premises in one case, he was simultaneously presiding over a valid custody modification involving Mr. Ojeda. That narrative is simply not true. My sons and I have not had contact of any kind with Mr. Ojeda in years. You would never know that from reading the extensive case record Judge Green created between August 2022 and January 2025. The absence of contact was not because we were violating court orders. It was because we were complying with them. And the existing court record shows exactly why Judge Green's narrative is false. In the spring of 2017, two separate temporary restraining orders were granted for each of my sons. This led to the initial suspension of Mr. Ojeda's custody. After a year-long custody modification, a final judgment was entered in July 2018. Mr. Ojeda lost both legal and physical custody of our sons. He was prohibited from having any contact with me of any kind. The only contact he was allowed with our sons was 2 hours of weekly supervised visitation through a designated supervising group. In January 2019, the court found Mr. Ojeda guilty of domestic violence stemming from his continued harassment and violations of the court's orders entered less than a year earlier. In February 2020, the Missouri Court of Appeals for the Eastern District issued a 10-page opinion affirming the full order of protection entered on my behalf in January 2019. Then, in November 2020, Mr. Ojeda was found in contempt of court for continuing to violate those same orders. By March 2022, a court dismissed Mr. Ojeda's motion requesting a replacement supervisor after the supervising group refused to continue facilitating visitation due to his ongoing noncompliance and concerns for the well-being of our sons. In April 2022, Mr. Ojeda's attorney, Roseanne Horan, filed a motion to vacate that judgment, which specifically acknowledged that Mr. Ojeda had no contact with our sons as a result of the court's orders and judgments. That motion was dismissed by the court. All of this is established history in the St. Louis County court system. Then, in August 2022, during the same period of time, I began formally accusing Judge Green of criminal fraud and deprivation of rights under color of law in my divorce from attorney Rick Voitis. The history of the case involving my known domestic abuser was suddenly turned upside down. Judge Green began issuing orders that asserted the exact opposite of reality. He claimed I was in contempt for failing to comply with an order requiring supervised visitation with a supervisor named Karen Strong. That claim was entirely false. It directly contradicted the existing court record. But once that false premise was introduced into the record, every subsequent motion, order, and judgment began building on it. Each new entry relied on the falsehoods of the one before it, until the record had grown into a massive stack of filings that appeared coherent only if you accepted the original lie. Anyone attempting to read through that record today would quickly become disoriented. The record makes it appear as though my sons and I were participating in an ongoing custody modification, that we were having contact with Mr. Ojeda, and that we were even participating in therapy with him and a Missouri licensed counselor named Camille Reinhold. None of that is true. The narrative Judge Green created in that record is total fiction. The judgment entered by Judge Green in January 2025 describes therapy sessions and psychological evaluations that never occurred. I have never met a counselor named Camille Reinhold. There was never a court order directing me to see her. No medical records were subpoenaed, and I have never been diagnosed with the disorders listed in that judgment. Yet those claims now exist in public record accessible to anyone online. My sons, now 15 and 18, have read it themselves. There is no way to describe what it feels like for a teenager to read a false narrative about their life written by a judge. The record portrays them as participating in contact and therapy with Mr. Ojeda and Camille Reinhold that never occurred. It undermines their credibility. It makes negative predictions about who they will become in the future, all based on the assessment of a counselor they have never had contact with, but who claimed that she had. The entire record functions as a massive smear campaign. Judge Green needed that narrative because while he was constructing that public narrative, he had already displaced my sons and I from our home in my sealed divorce with Mr. Voitis, using the same method of fraud. Until Judge Green and the other individuals who committed this crime were held accountable, the credibility of the St. Louis County Judicial Circuit remains severely compromised. Missouri's oversight bodies responsible for regulating attorneys and judges have failed to protect the public. When legal professionals are expected to police themselves, conflicts of interest deter accountability. And when that happens, the court system becomes vulnerable to this kind of corruption. If this can happen to someone with no criminal history, a working professional and a single mother who documented the evidence every step of the way, then the question becomes unavoidable. How easy would it be to do this to someone else? I had no other option but to make the evidence public. Transparency is the only protection that exists when the system itself is used to conceal the truth. Now, every person who reviews the evidence on litigantontheloose.com or shares this story helps bring the truth to light.